You heard that?
Hello and welcome to another episode of Deploy Friday, the Platform.sh show. My name is Larry Garfield. I'm the Director of Developer Experience here at Platform.sh. And today we're going to be talking about a super exciting, high energy topic, international privacy law. Please don't run away. We'll make it interesting, I swear. And to make it interesting, we have two special guests with us today. The first is Carolyn McCaffrey, who is CEO and co-founder of ClearOps, and comes to us today from her secret island base, I see. So we don't know where she is. It's an undisclosed location. We're also joined by Brandy Bennett, who is a licensed attorney in California and certified privacy professional. And joining me from the Platform.sh side is our Chief of Security, Lieutenant Joey Stanford. I didn't tell him I was making that joke. So we're going to be talking today about the recent Schrems 2 decision in the European Court and what it means for you, what it means for your international business. So before we get into that, let's do a quick round of introductions. Carolyn, to start with you. Aside from living in a cool-looking mountain, ocean volcano thing, who are you? What do you do?
I'm all about privacy. So I'm an attorney by background. I was certified in privacy almost 10 years ago. And so I'm a privacy attorney and currently working at on a startup that is trying to fix problems in privacy.
Sounds good. Yeah. Brandy, how about you?
Well, I don't have a cool island base because I'm not a Bond villain, but I am a licensed attorney in California, and I've been doing privacy for the better part of the last 5 or 6 years. Specifically, I've worked in ad tech, mobile apps, including dating, video games, social. Social's really hard, guys. And I was most recently the VP of Data Privacy at Endeavor, which is the major talent agency and also owns UFC, Professional Bull Riding, and New York Fashion Week. So we did quite a few things there.
Okay. So to get into it, let's set the stage a bit. We had a recent ruling from the Court of Justice of the European Union back in July that invalidates something called the US-EU Privacy Shield. And this has a lot of implications for data rules around the GDPR. And this is probably an awful lot of mumbo jumbo for most of our audience. So Brandy, let's start with you. GDPR, what is it? Why do I care?
GDPR is the data privacy rule, the regulation, the general data privacy regulation that governs how businesses that interact and collect data of European residents can be managed. And it's a very comprehensive, very broad law and set of rules that applies to the entire European Economic Area, including currently the UK. Obviously, that'll be complicated with Brexit and whether or not they continue to follow those rules. But it really governs everything from, why you collect data, how much data you should collect when you build your platforms, how long you should store your data, how you should secure it, how you handle things like international transfers, which I think is the highlight of what we're going to talk about today, and really what happens when there's a breach or a not necessarily a security breach, but a privacy, like a misuse of data, and what harms can result, and the regulatory structure, the supervisory authorities, kind of the scope of their authority. And really the penalties, which I think is the big piece of the puzzle and why it's become so important to, not just European tech companies, but really global tech companies around the world.
Yeah. And if I'm not a European, I'm an American company or a Brazilian company or a New Zealand company, do I still need to care?
Yeah, absolutely. If you are collecting the data of European residents, people who are actually in the EU, you absolutely need to start thinking about whether or not, this applies to you, what your risk tolerance is as a business is a huge key part of this. If you're marketing and making your services actively available in the market, that's a big deal too. And you need to think about, what parts of the law apply to you. Spoiler, a lot of them. if you're providing services to customers who operate in those regions. You're an enterprise SaaS platform, and maybe you're not directly in the region yourself. You're not directly collecting that particular data, but you're providing services to, companies that do. For instance, when I was at Endeavor, UFC would stage fights and do marketing in the European market. That meant all of our service providers that helped us process and manage that data had to be compliant with GDPR if they were going to touch our European data. And that's a huge part of managing, as a business, managing your risk is understanding, when and where does the law apply.
So
but I think go ahead.
So it's not just I have European customers, it's my customers have customers who have European customers.
I
I'm
think
still potentially affected then.
Yeah, I think that's a really big key part when you're thinking about, the enterprise business. Not every business is and not every software platform, since I know our audience is largely developers today, not every platform is a B2C. It's not directly to consumers. It's quite a large amount of the software that we use in the world. And Caroline can talk extensively about this because she's building one of these. It's really meant to help those particular parties, other businesses manage their obligations to their end user customers.
Okay. So that's GDPR. That's something we all need to be worried about. The other piece here we're talking about is privacy shields. Carolyn, this is not a Captain America type shield, right? What are we talking?
Although that was often the joke when they first released the name of this particular treaty. So basically, under GDPR, in order for you to transfer the data, there's a determination of whether or not a particular country is adequate, and the United States has not been deemed adequate for data transfers, which means you have to have some type of mechanism in place for the data to flow between the EU and the US. And so there's three mechanisms that are largely used. The Privacy Shield was a treaty that the US entered into with the EU to allow for this data transfer. So an organization could self-certify. They could go and they could look at the principles that the treaty laid out, and they could say, yes, we'll abide by those principles, we'll pay our fee, and we'll become a self-certified company under the Privacy Shield. And that just gives us this blanket authorization to now accept data from the EU.
So I have a question.
We're talking about specifically records sitting in a database in Berlin getting copied to a database sitting in Virginia.
That's exactly
what we're talking about.
That's exactly
right.
So just a point of clarification to jump in here. It's not just the physical transfer of the data from server to server. One of the really big challenges in this space is that the way that transfer is defined under the GDPR is access to data is considered a transfer. And so even if the data is living on those servers, if you have a customer support center and say in the US, or you have a centralized HR function that's accessing those servers, that's considered a transfer. So that's where this gets really, really difficult, especially with all the legal changes recently.
It's a really good distinction to make, yeah.
So, all right, so we got that, and that's the status quo until something just happened over the summer. Joey, what happened?
The world exploded. So what?
Besides that, what happened specific to data privacy and privacy shields?
So we have a body in Europe which processed a court case, and that court case found a lack of adequacy, which is a really good question. We should have one of these two wonderful ladies explain exactly what adequacy means, but a lack of adequacy for Privacy Shield. And so effectively, it cuts off the legal method for transferring this data from the EU to the US.
Cuts off as in that kind of self-certification that Carolyn was talking about. It doesn't. So if we rely today on Privacy Shield to transfer this data from the EU to the US, and it relies on this concept of adequacy, right? Are we providing adequate measures, adequate controls, adequate protection for this data that's coming across based upon the principal standard of GDPR? And what the invalidation says is, hey, listen, in the past, as a European
companies were able to send their information to the United States, and also US entities were able to market into the European Union. What's happened now is that the court has said, no, this is no longer valid, so you're technically no longer legally allowed to do this. And this is sort of what the basis of the problem is if we're not legally allowed to use this one mechanism called Privacy Shield, is there another way for us to still affect this transfer of data? Is there another way for us to protect the data? That's really the question.
And it's both protect and prove that we're doing a sufficient job of protecting, because you need both parts of that.
Yes, absolutely.
Okay. So you said something about adequacy. That sounds like a legal term in this case. So to one of our attorneys, what does adequacy mean here? What is adequate?
I'm gonna let you do
So
it, Brandy.
I guess what I would call it is, Europe has pretty high standards for data protection, right? In Europe, your data privacy, your data protection rights are considered a human right. They are the highest right that you have. And what adequacy really is when they transfer the data to the other country, are those countries' laws as good as our laws? Do they treat and protect data, as robustly, as strong as we do? And the answer, in some cases, I believe pre-GDPR, there were 13 countries that had an adequacy decision. There's certainly a spread of GDPR laws around the world to different countries now, where other countries are trying to align themselves with, to get adequacy post GDPR now. You see that with Brexit in the UK. One of the big negotiating points in those discussions is, whether or not there's going to be adequacy for data transfer. But I think at the end of the day, it's really relatively simple. It's, are my people going to be protected to the same standard as the GDPR? And obviously, in the case of the United States, we had, the limited protection of Privacy Shield that was supposed to escalate US privacy laws to that GDPR standard. And the court case, Schrems 2, named after Max Schrems, who is every privacy lawyer's not best friend. And I'll just leave it at that. But that basically it was invalidated, that the US laws were not, and the extra protections of Privacy Shield were not sufficient to reach that level of adequacy that European regulators demanded.
So if I'm a company based in the US and I've got servers in Europe or vice versa, that means I can't assume that what I'm doing with my data is now legal as far as Europe is concerned.
Yeah,
so
I mean,
now what do I do?
Yeah, and that's the question that we're all grappling with right now. And Caroline, Joey, please feel free to jump in here. To Joey's point earlier, there are additional mechanisms to transfer data outside of the EU. Traditionally, there are things called the standard contractual clauses, which are about 8-page addendums to contracts that talk about how companies are going to handle data. And then there are what are called binding corporate rules, which take quite a bit of money and a long time to prep your organization. And essentially, they're rules governing internal transfers for multinational organizations. If you have a large, complex organization, you have teams scattered around the world, you might go through the process of standardizing your rules and your practices and then submit those to one of the supervisory authorities in the EU, and they would essentially approve those, and you would negotiate those out to get those approved. The problem with the Schrems 2 decision is that it's thrown those mechanisms as well into question. And so we're in a lot of really challenging kind of gray area right now. We're kind of waiting for a lot of additional guidance. A lot of companies are trying to figure out, what does this mean for adequacy? One of the things about the Schrems 2 decision was the ask for additional protective measures to essentially protect the data from being accessed by the US federal government under federal surveillance laws. And that's really the core, I think, of Schrems 2. We can talk about all the different little nuances here and there, but at the core of it, it really goes back to national security laws here in the United States and the access that the government may have to data, and how can European residents be protected from the US government.
I just want to chime in. Just to be clear, though, the court's opinion did say that standard contractual clauses and BCRs are still valid mechanisms. So it didn't invalidate them as mechanisms like it did with Privacy Shield.
Yeah.
It's just that when you read the opinion, it's tough to get over the fact that the basis for the opinion, when it is specifically applied to the United States, doesn't also mean that any use of standard contractual clauses in the United States is going to be a challenge. But for the most part, people are basically saying, go with the SCCs, the standard contractual clauses for now.
Right.
We'll figure it out.
Okay. So it sounds like, to make sure I'm following here, you can, as a company, prove adequacy independent of your national laws, but the reliability of doing so is now a question mark because we haven't figured out what is good enough absent the national laws. Is that roughly what we're looking at?
I would say it's a little bit more, little stronger.
Okay.
There's still a lot of gray areas, but we have, as Carolyn mentioned, like the standard contractual clauses are currently deemed adequate, means we are authorized to use them, and it is a legal mechanism for us to ensure that the data is protected. But this is only one piece of the puzzle, right? You have this legal mechanism, the paper, and then you have the really down and the dirty technical measures that are required in order to do this. Now, hopefully, we would hope that since we're all smart and people take this stuff seriously, that these technical measures are already in place. And those technical measures, to name a few, would be encrypt data in transit, encrypt data at rest, perform, well, then there's some organizational measures you can do, like perform a review of all of your vendors, make sure that you have all the legal pieces, make sure that your transfers to those vendors are encrypted and that they encrypted, right? So you have this sort of full review that you end up doing across your organization to verify, to prove to yourself, which you could then prove to your customers, you know, that yes, we've looked at all this and we're safe, at least for now. And then as the new laws come in, as we get brand new, so they're going through in Europe, they're going through a new project to upgrade the standard contractual clauses, probably happening. I've heard some additional effort, maybe the ladies might know this too, that they're also going through like the next revision of GDPR. I believe those are two separate discussions though, but we'll get some updated guidance, right? And we'll get some updated paperwork, and then we'll try to do that. Now, what complicates this, and this is interesting, I think, is that right now, because of the fragmentation in Europe, we have different supervisory authorities, as Brandy was mentioning, throughout it. So there's one in France, one in the United Kingdom, one in Germany, right? They all have different opinions about what this court case is, and they're issuing different levels of guidance to the companies that they are the supervisory authority for. So we have this fragmented playing field, which is what makes it a little bit interesting. Some of the data protection authorities are taking a very measured approach, and others are issuing some very strong recommendations.
Yeah,
lots of uncertainty.
That's been a huge challenge. There's been a couple supervisory authorities in Germany that basically have said, and now you can't transfer data to the US at all. And we saw Facebook, which was the original, I think they were through, civil procedure. They were actually the plaintiff in the Schrems case, but really they were the defendant. Schrems was trying to get those transfers invalidated. They
Anyone
were
who thinks
ordered by
technology is too complicated needs to look at law.
Right?
They've had a lot longer than technology has.
Exactly. You would originally, like I said, they were supposed to be the defendant, but somehow through, legal procedure, they became the plaintiff in this case. But, the Irish DPA, or Supervisory Authority, Data Protection Authority, they actually told Facebook to stop transferring data to the US last week. And then literally 2 days later, an Irish court put that on hold and put an injunction in place so that they could continue to transfer data while they tried to process what the heck Schrems 2 means. So it's a little bit of chaos right now. It's very complicated. I feel really bad for my European counterparts in the UK, because not only do they have this mess, but they've got Brexit going on, and they're supposed to figure out, are we part of the EU and GDPR anymore? Are we not? What does that mean for our trade deals that we're going to put in place post-Brexit with all these different countries? and how do we just, how do we build, and how do we advise our clients how to build their products and services?
That's like a whole nother show, Brandy, is the adequacy decision with the UK and
Yeah.
You need my friend Emily then, because she's in up to her eyeballs in the weeds, and I think she's ready to tear her hair out on a weekly basis, if not daily at this point.
So if I'm an organization that my business is mostly in one place, but I'm using a cloud service provider, which means I don't actually know where the hard drives live at the end of the day, what additional risk does that give me?
I mean, that's a very, it's a very practical question. And I've definitely been dealing with these types of practical questions with customers. When it comes to using the cloud, generally speaking, you pick the region, at least, of where the cloud provider is and where those boxes are located. So you should at least be able to know if it's US based or EU based. If you're in the United States and you're using a US cloud service and you're processing data by European customers or users, then what I recommend to people is that you take a look at their documentation. I mean, a lot of people use AWS, so you go look at the AWS documentation, and then you have to start taking this analysis step by step. So does the data, is it encrypted in transit? Do you have keys to unencrypt it when it comes onto the US soil? Or is it anonymized or pseudo-anonymized? Because that even gives it, anonymization under GDPR, GDPR doesn't have to apply. But then after that, if it is coming in and it is, you are able to see the data in plain text, how frequently have you been getting government requests yourself as a business? Have you received subpoenas? Have you had to turn over data in the past? And this is the type of information that your European customers will be really interested to know, because at the end of the day, it's a risk assessment they now have to take. Mm-hmm. Should I continue transferring data to this US provider who's got a cloud service in the United States, or should I not? And yes, which DPA is relevant as well for them, but if I can say to my customer, I've never received a government request, and here's some additional protections I'm going to try and put in place if I do receive a government request, then at least your European customer can say, okay, that risk is tolerant, or that risk is not tolerant. And then of course you should know what the data is. If we're talking about data that someone wouldn't care came into the hands of the US government, that's a different type of data than if it's like your name, your address, or something else that your end users are really, really protective of.
So Joey mentioned a moment ago some tactical things that matter. And it sounds like you need to both follow the spirit and the letter of the law here in order to qualify, once we figure out exactly how to define qualify. So given that there's still a lot of uncertainty, what are some tactical measures that companies can take to cover themselves once the legal landscape is sorted out, so that they're in a good place from a GDPR compliance and data travel compliance standpoint? And this is questions for everybody, since I hope there's a long list that we can do. It's not a short list. Or maybe I hope it's a short list, I don't know.
I think we're, like I said, we're all in a little bit of chaos right now. We're all in a little bit of a waiting period. We're trying to see if there's going to be additional guidance that's going to come out. But there are some practical measures that you can take even in advance of that. I know Joey talked about encryption. Caroline talked about looking at your vendors. That's a huge part of this, I think, is looking and doing that risk assessment of your vendors. The challenge, of course, is that, does that scale as you build a business and you add more and more vendors to your business, to your platforms, you have more than one product, et cetera. Does any of that scale? And that is the real big challenge I think we're looking at right now. And the other piece too is, we don't really have great tools. Caroline is building one of them, which we're very optimistic about. But privacy tech from a regulatory perspective, helping us manage these obligations, is very immature right now. And so, we're all kind of scrambling to build solutions in place. But if I'm an engineer, I'm thinking about things like data minimization, not collecting anything more than you need to provide the services. I'm thinking about whether or not I have, storage minimization. Am I holding on to that data too long? One of the lessons we took, when GDPR went into effect was how many of our partners, our businesses, our clients were collecting data and holding on to it forever. And that has storage costs. Storage costs have dramatically decreased in the last 10 years, but it still costs money to store all that data. And that money can definitely be better directed towards helping you comply with GDPR in other ways. But, you look at, I think Carolyn mentioned it earlier, pseudo-anonymization, where you're masking the identity of users behind, other kind of identifiers, usually some kind of user ID. And that user ID is decoupled from, I think, precisely identifying information such as email addresses, phone numbers, geolocation coordinates. So I think those are three big issues. I think, Carolyn, you can talk more about that if you have some thoughts on it.
I was actually going to go in a little bit of a different direction just because you covered that so well, which is, I do think I say to people, first thing is don't delist from Privacy Shield quite yet.
Yeah.
And the reason for that is because when you delist from the Privacy Shield, first you have to pay a fee. Secondly, you have to answer a questionnaire as to why you're delisting. And then they send that questionnaire to the FTC. And the FTC then looks at the company and says, why did they all of a sudden decide not to abide by these principles?
Right.
So the last thing you want right now is an FTC review. Yeah. But the second thing I say is, sorry, go ahead.
Just to clarify, delisting means telling the government, I don't think I'm Privacy Shield compliant anymore, by the way, peace out. That's delisting?
Yeah, basically, I'm not going to comply with it anymore.
Okay, yeah. So don't do that.
Yeah.
Even though we don't know if it matters anymore, don't do that.
I mean, if it's really expensive for you, maybe it makes sense because you would rather not have the expense anymore, and therefore you delist because it's providing no value to you. But just be ready. Be ready for the FTC to come say, well, for all the data transfers prior to your delisting, that still is covered under those principles. And what's happening, going forward. And so in that context, you really should make sure that you have all your SCCs, all your standard contractual clauses in place, because the FTC is going to come to you and say, well, did you then move to another mechanism? Because clearly you still have to abide by these principles because you're still transferring the data. So those are the things I would also say is on that. It is a short list because, as Brandy keeps saying, that it's such a gray area. We're kind of working with what we've got. But those are definitely the couple of things that I have been saying to customers, to clients, that, stay on the list if it's not too expensive and start getting your SCCs in place.
I'm going to add one more to the technical ones, and that is something we've actually seen the German supervisory authority mention too, and that is that customers should encrypt and encrypt their own data and use their own keys for it. So it's a little different, right? If you think about it, a cloud service environment, you have cloud service, or platform as a service, you have an infrastructure, and you have all the stuff that's out there and that you rely on that company to manage that piece. But now when we talk about your own data as a customer, right? We want to be able to, as a customer, we want to be able to send that data across. We want to make sure that's encrypted in transit, encrypted in rest, and we don't want anybody else to have the key, because if the key is intercepted, it's like opening the purse, right? And so we want that, and there's ways to doing that, such as encrypting at the database level, et cetera, if you're on a cloud service. So that's kind of a big thing. The other thing that was interesting when we were in this exchange was PII. So I call it PII, personally identifiable information, because in my view, right, GDPR is about, can you identify an individual? And PII, in my case, seems to work great in an international audience because it seems to be a little bit easier to grasp than what is a data subject, that kind of term. So it's interesting for me. It's always been interesting for me to say, look, United States, if we have a business card, but anything that's on a business card is public knowledge. It's not really protected data. But when we go to the EU, it's completely different. It involves this thing called consent. And so even though it might be it might be out there where you can find it in places like LinkedIn, there's this whole consent process that goes with the PII. So back to, I think it was Brandy made the point about there's different types of data, and there's approaches that you need to take when you look at that data. And I think, ladies, would you agree that we should use a risk-based approach to try to tackle this problem, or something different?
I think you took the words right out of the Irish Supervisory Authority's mouth. Helen Dixon very much loves to say that GDPR is a risk-based approach. And, there's a risk tolerance for your organization. There's a risk tolerance for your customers. There's a risk tolerance for the type of data you're dealing with and the data subjects you're dealing with. And I think those are the four factors you really need to think about when you're kind of preparing your own internal analysis, what I call a risk framework for an organization. Both in the US and in Europe, children are protected. So you have, and the age limit differs in different jurisdictions. Sometimes it's 16, sometimes it's 13, sometimes it's 18. It just depends on which country you're in, which makes it a little bit of a challenge, especially if you're offering products to individuals who are in that teenage bracket. Social, gaming, obviously, anything kind of geared towards that particular type of audience, and especially if you're building something for kids, like a Roblox, like a Minecraft, anything Disney related, essentially. In terms of the data and what's protected more seriously, think about your business contact email, right? What we call business contact information. My business email is very different from my personal email, right? So we would treat those a little bit differently. But even more serious, so government IDs, social security numbers, driver's license numbers, passport IDs, financial account information, so your bank accounts, your PIN numbers, you have to deal with PCI compliance if you're collecting a lot of that stuff. Your biometrics is a huge hot button area. So anything to do with your fingerprints, your voice prints, Face ID, that's a huge area both overseas and abroad, or overseas and here in the US domestically, under Illinois, particularly under Illinois law. So, you have these kind of different factors you have to consider. And then, who are you providing services to? Are you providing services to marketing clients? Marketing clients tend to think a little bit more fast and loose with data than does healthcare providers or insurance providers or banking institutions. And, if you're going to get in bed and you're going to play in those markets and try to attract those kind of customers to your products and services, then you really need to be thinking about what are the requirements on them that they're going to try to flow down to me. And that's going to impact your risk analysis.
And that's really the tricky part with all of this is that flow down that we mentioned before, where most companies these days are using a dozen providers who may have a dozen providers each behind the scenes. So you could have 200 companies that somehow have access to your data, half of which you've never heard of, but you're still responsible for their behavior.
Right. And as a business, I don't know about you, Caroline, but as an in-house attorney, I've had to take a little bit of I can only reasonably go out one layer, right? I can go out one layer to my vendors. I can go out one layer to my customers, but not to their customers, right? And so it's, you can only control what you can control. And then it's about what flows down in your contracts that they have to bind, their chain on. And when you're doing your diligence and choosing your vendors, or when your customers are doing their diligence and choosing you as a vendor, you can only go one layer out, and you have to do the best you can. And that's why this is such a challenging area and such a challenging risk to manage, and why it's really on all of us to build responsible products that manage and handle the data of individuals in a responsible, ethical way.
Brandy, let's talk about that vendor. Let's talk about that vendor piece again. So if I have vendors, and I have I've got lots and lots
Truly
of vendors.
hypothetical here.
Yes, what would you look for in a vendor to have the warm fuzzies? So I think there's really two pieces, right? There's the legal aspect, which you need to have, and then there's
Mhm.
what I call the warm fuzzies, right? This is to you, Carolyn, as well, right?
Yeah.
So would you look for things like they're certified with PCI or SOC 2 if they had something like that? You know, what are your recommendations? What should we be looking for when we do these vendor reviews?
Yeah, Carolyn, I do want to throw this over to you, but let me get a couple thoughts out here real quick. So one, I have a pet peeve, which, having negotiated, I don't know how many deals with vendors over the last 5 years, I absolutely cannot stand one size fits all programs where we're going to throw the most robust layer of data protection language in our contracts. We're going to look for all of these things. And at the end of the day, you're getting 500 emails from my employees to do a wellness program. Come on, that's overkill, risk-based approach, right? We go back to those words over and over and over again. So when I build these kind of programs for companies and when I advise clients, I talk to them about having that risk framework. And that risk framework is really the core of everything I do, from a policy perspective, from a vendor procurement perspective, from how I'm going to even think about the use case of that data. So I start with the risk-based framework. The higher up you get, the more you're going to ask for. If there's financial account information, you're looking at PCI, you're looking at SOC 2, Type 2, and you're not always going to get all of those, because depending on the vendor you're dealing with, if they're an immature, kind of early stage startup, they haven't gone through that part of their life cycle yet, where they've gone out and spent the money on that, to land those clients and to get that mature. So you have to, come up with, creative ways. Either you don't use that vendor, or if you really want to use that vendor, you start talking about, okay, well, how can we help them along that journey? Or what are the other things we can ask for? In terms of international data transfer, one of the things I had previously looked for was obviously Privacy Shield, but Privacy Shield is now dead. But at the same time, I was always a bit of a pessimist on Privacy Shield. So I advocated a belts and suspenders approach, and I kind of always tacked on the standard contractual clauses, on top of my contracts, just in case Privacy Shield was invalidated. I do ask, there is a security questionnaire that we give out that asks, any number of security questions, and that's usually led by my, if I'm lucky enough to have a security engineer or a chief of, information security officer, they tend to drive a lot of those inquiries, but, we would build that into the procurement process. But frankly, one of the things that I sometimes do, and I don't know if anybody else does this, sometimes I will actually go on LinkedIn and I will look at your company, and I will look at who works for your company. And I will be like, do you have a lawyer? Do you have a CISO? Do you have anybody with the word security in their title? I am, maybe that's not the best way to do it, but, I'm trying to
answer the question, do you have a clue? Really? Right? Have you thought about this?
Exactly.
Do I have any trust?
Yeah, exactly.
Or is it just the marketing people spending something?
A lot of it comes down to, it sounds like.
Exactly. But I want to throw it over to, I was going to say, I wanted to throw it over to Caroline,
because
like this is her wheelhouse.
Sorry. It sounds like a lot of it comes down to demonstrating that they're making a good faith effort, even if they don't have all of the T's crossed and I's dotted. They still look like they're trying to do the right thing at the end of the day.
Yeah, I would call that the sniff test, right? It's actually, and that's also what Brandy was kind of ending on, was the sniff test. It's sort of this, and everyone does it actually at some level, which is you do some sort of public data search. You just go online and you look at the website, or you look at LinkedIn. Most people do try to not go on the website because that's marketing, and so that's been tailored to look good. So you try to pull in other sources of information that can sort of verify that this particular company is legit. And that's the sniff test I'm talking about. So what I actually often tell people is you break up your risk into, I usually say a minimum of 3. You can do more if you want, but it gets more complicated. But you sort of say risk level 1, 2, 3, 1 being your highest level of risks. What data are they actually getting? And if it's that highly sensitive health data or financial data, then they go in risk 1. And that means they have to satisfy all the bells and whistles, whatever that is, SOC 2 audits. Don't have a SOC 2 audit, you get the CAIQ security questionnaire that has hundreds and hundreds and hundreds of questions on it, and you have to go through that. Risk
Joey's
level
laughing. I
2.
think he's been on both sides of that giant form now many times.
Yeah.
For the audience, we're basically describing Joey's day job here at Platform is what we're talking about right now. At a fair assessment, Joey? Yeah.
But then you go to risk 2, right? Risk 2 is a medium risk vendor. So maybe they're not getting that highly sensitive, but you've identified that they're getting enough data that it warrants some sort of medium level of review. And then you get your risk 3, which is they're getting nothing. Or, we're talking about maybe it's your event, you're going to go present at a conference. Every piece of data you're giving to them anyway is already stuff that you want the public to see. So you really don't care. And so you might just do a basic search on them just to make sure that they're not going to take your money and run. But other than that, you don't really care. So that's really the best way to do it, is to have these different categories so that you're not bucketing startup event company as risk level 1, and they have to give you a SOC 2 that they can't possibly do, and they're never going to do because they've never been asked for it before, right? But if you have AWS as your cloud provider, they have all their security documentation online, and you're going to do your review of them because guess what? They hold the keys to the kingdom. So that's generally how I tell people to process it. And as Brandy said, there's things you can substitute in for those risk categories of 1 and 2, where, if they don't have X, they give you Y instead, and it satisfies enough.
Okay. Now, in some of our pre-show talk and planning, I understand there's something going on with the U.S. Foreign Intelligence Surveillance Act, or FISA, that is all kinds of scary legal mumbo jumbo. So I'm going to hand this one over to Joey because he handles the scary legal mumbo jumbo for us. So Joey, what does FISA have to do with any of this, and why should I be scared, or shouldn't I be scared?
So FISA is interesting, and by the way, that's the actual pronunciation of it. So it's the FISA stands for the U.S. Foreign Intelligence Surveillance Act, but they themselves, the actual board calls themselves FISA instead of FISA. But it's interesting. So the FISA, as we were talking earlier, the act itself really is about interception of data, wiretapping, if you will, of transferring data across. Different from what other people are familiar with also, which is the Cloud Act, which I always say is turn out your pockets. Here's my request, give me everything you've got. So we're specifically around Schrems 2, there was some commentary in there about this data interception that was happening, about accessing. And I'll actually have a quote in front of me that says that we allow the NSA to access data in transit to the United States by accessing underwater cables on the floor of the Atlantic, and to retain and collect data before it's arrived in the United States, being subject thereto. FISA, which is kind of scary if you think about it, right? There's a lot of like, oh my goodness, right? But at the end of the day, in my opinion, if you think about it logically, what happens to your, let's just say email, right? When you send email, is it encrypted? Generally not. It gets sent around the world wherever you're sending it to, and at multiple places and multiple hops, it could be intercepted in there. When you send a zip file through, that could be yanked out by anybody, not just the government, but just any bad actor that's along the route. If you send an encrypted zip file and the password in the same email, and somebody intercepts it, well, they can decrypt it right there as well. So this is not something that's technically new. It just happens to be that in this case, it's related specifically to U.S. foreign intelligence operations. So let me open it up to Carolyn and Brandy. There was this component of the Schrems 2 court case that really points the finger at U.S. intelligence. Just beyond what I've said, what does that really mean, and what sort of protections do we have for this? What are your guidance that you would give customers?
Well, I like to tell people, I like to start with the Fourth Amendment, right? Because most everyone knows the Fourth Amendment in the United States. If you're a U.S. citizen, it provides for due process. That's for U.S. citizens. What do European citizens get? Do they get the benefit of the Fourth Amendment when they're in the United States? That's kind of the crux of what this decision is about, because if you're a U.S. citizen, due process. European citizen, maybe not.
And it's not just non-citizen in the US, it's also a non-citizen's data in the US, which is where it gets really tricky if you have, someone living in Prague who's doing business with an American company, and so their data ends up on a server in New York. Now what? What are the legal protections? And that's my understanding is that depends on which judge you ask at this point. Is kind of the standard. And then the nervous laughter, I'm assuming, is because we're all scared of that.
Yeah, I mean, it's tricky, right? Fisa technically applies only to foreign individuals. It's obviously growing out of supposed to, right? It's obviously growing out of the Patriot Act post 9/11 and all of the protections we put in place as part of the war on terror. And then obviously it's tied up in all of the Snowden revelations from back in, what was that, 2013, I think, where it was basically being used as a predicate for the overbroad grab of not just foreign data but US data. I think, to your point, it is a little bit in that it is a little bit tricky in that we don't know how individual judges are going to interpret this. A lot of us don't have, I'm not a national security lawyer. I've never worked, for the federal government. We have ideas based on whistleblowers, based on, leaks and media reports of what the government is doing with the data. We don't always have access to, actual knowledge of what they are actually doing with the data. One of my favorite tinfoil hat conspiracies is, did you guys know the CIA has a venture capital firm, and they invest in any number of, tech companies around AI, machine learning, big data, et cetera, for the national security apparatus so that we can compete with the rest of the world and keep Americans safe. But also, what does that mean from a security perspective, from a FISA perspective? Historically, FISA has only looked at communications data, right? It was limited, I think, to phone calls and emails, and basically they were looking at your known contacts, right? The goal of this was always about terrorism and protecting from, following the finances, following the context of who was talking to who. The problem is, as FISA continues to come up for renewal in Congress, it comes up every few years and they have to reauthorize it and refund it. Most recently, there was talk about expanding the definitions of what data was subject to FISA, which I think is a really, really big problem. And I think this is where in a global world where we have data in the commercial, world going around everywhere, and it's helping us, run our businesses and get clients and customers globally, we're running smack into that national security impetus, right? We're into that apparatus. And so, I think there's definitely some challenges in that space that, frankly, it's how do I advise my clients? Yes, tell the government, no, they can't have your data. How do you advise an individual small business client or even a large business client, unless you're Microsoft or Apple, you don't necessarily have some of the resources to push back on a lot of this stuff. And that's where organizations like the EFF and the ACLU become really important, because they will often take cases around this stuff to protect the privacy of, either US citizens or even non-US citizens, that may be subject to, whether it's FISA or other national security requests, other subpoenas and things like that. They will take cases like that. So, it's hard to figure out where the boundaries are around what the national security apparatus is doing and what they are wanting to do. And I think that is the big gauntlet thrown by Europe, when they dropped Schrems 2, and they basically, said, hey, get your house in order, stop spying on everybody and their brother. And obviously I think there's, going to be some pushback on that. And that's a congressional thing. That's a government level concern that I don't necessarily know that an individual business can tackle that.
That's an excellent segue. One of the questions you want to ask: what can or should the U.S. federal government or state governments do at this point to make life easier, more certain, more secure, less, I don't know what's going on, than what we've got now? And I mentioned both federal and state because federal is not the most effective organization right now. So given that, what are some things that the government levels could be doing that we should be pressuring them to do to make life easier and safer in this regard?
Nobody
One of
wants
the
to take
desks
there
there
the.
is an answer. That's
Let's
kind of
talk about a
disturbing.
national privacy
I'm trying
law.
to let
Maybe
you
that's
guys
good.
talk a little bit.
Yeah.
Yeah.
Carolyn, tell us about a national privacy law. I know you want to.
Yeah. Well, yeah, so there's been talks about a national privacy law for years now. In fact, when GDPR was being drafted, there was pressure in the United States to kind of beat it. We knew it wasn't going to, but it definitely didn't. And so there have been attempts. There's been bills that have been proposed, but have not made their way through. So it's a space we're watching. There's people who take bets on this, have been taking bets on this almost every year for the last 2 years about whether or not the US will issue a national privacy law. And people who keep winning are obviously the ones where the law is not going to get adopted. States are pretty active, specifically California, with the CCPA, which is GDPR-esque. And then you have the amendment coming, which is the CPRA, or the next proposed law for California. And so there has been some speculation that California as a state will be deemed adequate, but most practitioners don't believe that's going to be the case because the US surveillance laws trump that state law. So yeah, lots of activity to happen. I think if there's something that we should all advocate is for that national, federal privacy law. It's just
So a US version of the GDPR, basically.
I mean, or yeah.
We'll never get. I don't have any confidence that we'll get there. My current my current prediction, and this is just me. My current prediction is within 2.5 years we'll have something, and it won't be what we want, but we will have something. That's my prediction with this. But it's the other interesting piece is if you follow the state landscape in the United States, you'll see there's almost a dozen now bills, privacy-related bills that have gone through. Some have been ejected, some have tabled, some have actually are in the past. I think Texas was the one I just recently saw. They're doing something down there. So you have all of these that are starting to build, and so at some point we're going to be fragmented in the United States, just like Europe. Well, we're already fragmented with California, but when we're going to fragment a little bit more. And the reason this is important could be important. It's a little different than Europe. So in history lesson, in Europe, right, we got to the GDPR in part because of something that came before it called the Data Protection Directive. The Data Protection Directive was a direction given to each of the member states to go create their own privacy law based upon this set of principles. And what it's great for privacy, but what happened was that we saw different laws in different countries in Europe, and it prevented it didn't prevent it, but it threw up a slowdown barrier, a speed bump between different countries and how they would do commerce with each other. And we're going to, I think, if we continue with this fragmented approach in the United States, we're going to see a little bit of that there. And we see the beginnings of this right now with California and CCPA, do not sell. If it's just do not sell, it's okay, but if you do sell or you fall into the provisions, then there's a little bit more complexity that goes along with it. So I think what we really need is to have some sort of unifying legal framework, if not an actual law, regulation inside the United States that smooths this out, that gives us some basics, and that can be easily applied to or in support of Privacy Shield to then regain the adequacy decision in the European Court. And I guess that's one of the really big questions: is what happens with Privacy Shield now? Where does it go in, and do we expect it? So before Privacy Shield, we had Safe Harbor, everybody's favorite Safe Harbor. Safe Harbor was invalidated in October, and in February, the U.S. and the EU had put together a new proposal called Privacy Shield, and 2 months later, it was approved by Europe. We're rapidly approaching that sort of view, but it's going to take us a lot longer because we still don't have agreement. And principally, it's because of what we were talking about earlier, this Fisa, this foreign intelligence sniffing piece.
They did announce that there's discussions happening for an enhanced Privacy Shield. So
2.0.
So
yeah,
we really
I'm not optimistic.
We really need for the U.S. government to agree to really stop spying on people. We mean it this time. And then the contracts and treaties might actually work for a change. That's kind of the TLDR the government front.
there's a little bit of nuance there where some of it is based on the ombudsperson setup and that fact that a data subject in the EU can actually be able to have their rights determined by an independent and fair tribunal. And that the US didn't create that with this ombudsperson because it wasn't a tribunal and it wasn't independent. So there are things that can be discussed and potentially there can be improvements. So it's not just as blanket like US can't surveil. It's a little bit more.
Yeah, I think too, I want to interject here and defend the US a little bit, just a skosh, which is we are not the only country, including EU countries, that have these kind of extensive surveillance operations for national security purposes. We can point at the UK has, huge, they love their CCTV all over the place, everywhere you go. Germany has a pretty sophisticated security apparatus. Australia, China, you can go down the rabbit hole of China and how much it feels like they're, basically trying to create Minority Report over there. But we're not the only country that does things like this, and we're, the EU does not have clean hands in this space. So I think there is some room, and even when they put GDPR in place, they didn't actually, one of the things that they didn't cover that they left for the individual countries, because really they couldn't find a compromise, I think, on this is national security, right? It's one of the so-called derogations, which are left up to the individual countries of the EU to legislate it. So, I do think, it's not that we don't have to not surveil. I think Carolyn brings up a really good point, which is it's the surveillance plus the lack of recourse. How do I defend my rights if I don't even know it's happening, right? And if I don't, and even if I know it's happening, how do I then go and get some remedy? How do I get off a no-fly list? How do I get out of a terrorist database? How do I get out of, any number of these systems for tracking? And I think that's where, maybe if we end up at an enhanced privacy shield, that's where we land. I also think we're in a really contentious election cycle. So I don't have any confidence, anything's like, if I'm Europe, I don't have any incentive to negotiate with the US, frankly, because I'm sitting there fingers crossed that the election turns in whatever direction I want it to turn, and I'm going to wait until that. And that's when I think things will start to get serious, is in 2021. And then in terms of federal privacy law, I know that the Senate is starting hearings on this. I know there's lots of proposed bills out there. Everybody and their brothers throwing down a bill that has something for somebody. So the question will be, how do you consolidate and figure out where the compromise is on all those bills and get them all working together? I sometimes think we're not going to get what I call an omnibus bill that covers all the data. I think we're going to get pieces, because Congress isn't really good at acting big, but they are good at acting in little areas. And they ride it along with appropriation bills and things like that. So like facial recognition, I think we could get something on national data breach standards.
Yeah.
COPPA, I think we're going to get some updates too.
Yeah, it's difficult to do a national bill when you have HIPAA already and FINRA and all the COPPA. So it is a very,
yeah. And even if we do get a federal law, does it preempt HIPAA and GLBA and COPPA and all of that? Does it just replace all of those? Because otherwise we're still at this level of insane complexity. As somebody who practices in this space, some of the biggest challenges I have are finding out which law applies where and how they overlap. When do I have to think about, FERPA and, CCPA and where do they leave off and what's covered, what's not. Those are some of the harder, I think, more nuanced areas to have to deal with from a legal perspective. And then, my job as a lawyer is to bring that to the engineers and the developers and say, okay, here's what we have to accomplish. Let's talk about how we can engineer to that. How can we build our systems to that? And what resources do we have? Do we need, work that into the schedule.
So we have a question from the audience that I think is actually a great way to wrap up. Boyan Borisov, I hope I pronounced that correctly, asks, obviously the rules and the regulations are constantly changing. Is there a source of information, websites, something, tooling, which can keep us informed about what's going on? And more broadly, I suppose, what other tools can we look at to help make this process easier for us, given this uncertainty and shifting landscape?
I'm a member of the
silence is not reassuring.
IAPP.
Yeah.
No, we all have our sources. I think we're waiting to tag each other in. I'm a member of the International Association of Privacy Professionals. Some of their content is free, some of it's paywalled. That's where most of the, kind of, I would say it's nonpartisan, right? Information is presented about laws, not just here in the US, but also globally. So that's a really good source. I have a handful of law firms I really liked, and I follow their updates in various spaces. Some are better than others. I like Field Fisher is one of them. I like Oric. So those are just some law firms that I know people at, that I know who are good in this space, and that what they're putting out there is a good kind of reasonable, not sky is falling opinion on some of this stuff. And then I think a lot about trying not to chase the specificity of the law, but trying to think about principles, and trying to build the programs and the rules around principles, and things that I know are common and that underlie all of these specific nuances. And I think, those come down to things like data minimization, storage minimization, giving customers access, notice, and choice. We can talk about the mechanism of consent, and there's a lot of nuance in that under different laws. But at the end of the day, some activities do require consent, and knowing when you have to implement that. So thinking about it from a principles-based perspective rather than chasing individual laws, because this is such a frothy area right now.
Yeah.
All right, I'll take it. So I would definitely agree with the IAPP recommendation. They've got some really good, because it's their job, they surveil all of these different places for privacy. So my recommendations would be certainly IAPP. I actually happen to like Lexology, which is a lawyer consolidated database. They're really good for summaries. You have to create an account for it, but they'll give you can select what region you're interested in around the world. So in my case, because I'm global, I can pick and choose the countries that I'm really interested in. And the other one I happen to like is Hunt and Andrews Kurth. They've got a nice little newsletter that they send out that gives us little blurbs that are very much in line with, or in the same style that IAPP does, which is, here's the summary, this is why you should care, here's the link to read more. Carolyn?
Yeah, so I would add the Future of Privacy Forum. I think they publish quite a lot of content, and they also go by different types of technology. So like they have one on AI and facial recognition and stuff like that. I also, for the European side, I do like to follow the ICO. I think I forget the exact website, but they just have a very balanced approach to what's going on over in Europe. For me, they put out a lot of good content.
ICO.co.uk.
Yeah, thank you.
We'll make sure links to all of these get added to the show notes. I think that just about wraps it up for today. Do anyone have some final remarks before we close up?
No, I guess I'd just say that, yes, I guess I have final thoughts is based on what happened with Safe Harbor and sort of the wrap up of this conversation with Privacy Shield. We are still operating in a gray area. There's more to come. So while there is a tendency to do wait and see, I do strongly also believe there's proactive measures that businesses can take right now, whether they're processing HR data across the pond or if they're processing data subject information, then there are some measures that people should be at least contemplating for their businesses to make sure that they're staying at least as much ahead as they possibly can when it comes to the questions and the potential ramifications that this decision, the invalidation of the Privacy Shield caused.
Yeah, I think Caroline's absolutely spot on right here, and that's staying, doing some things proactively, but also staying flexible is really important in this space. This is one tiny little area of data privacy law, and a lot of things are in flux. This is one of the most pressing right now because of how much data goes back and forth across the ocean. But realistically, privacy just as a field in general, really does require an understanding that, everything's in flux, everything's fluid. The laws are changing rapidly. Technology continues to change rapidly. And it's actually kind of becoming one of those very popular areas for people to put down ideas for Congress people and industry trade groups and state legislators. All of them are putting down their ideas because it's actually becoming something people are thinking about, and it's something that they can really kind of push out for their campaign messaging. So just be aware that this is a very active area. I've never seen an area of law this active in my career. I don't know about anybody else. So be flexible and be ready for it to change. And please don't kill your lawyers or your privacy or your security pros when they do come to you and say, hey, that thing we built 6 months ago, yeah, sorry, we got to change it.
Sage advice when you're building anything these days, expect it to change.
Yeah.
All right, well, I think that just about wraps us up for today. Thank you to our guests. Thank you, Joey. And please remember, everyone, nothing here is legal advice. Please consult your own legal counsel. You need to include that disclaimer in here somewhere. We'll be back next week with an episode completely different, talking about Lando, a local development tool that we're partnering with here at Platform. So looking forward to that. So with that, thank you, Carolyn. Thank you, Brandy. Thank you, Joey. Thank you to all of you listening. And take care. Go ahead and deploy. It's Friday. It's safe.
Thank you, Larry.
Thank you, guys.
Thank you.